What's up, everybody? Happy Juneteenth pre-weekend. A lot of folks are celebrating. To our American Freedmen graduates, I'm wearing a lei to celebrate you, celebrate your success, whether it's kindergarten, 12th grade, college, you getting your master's, and all those fun things that we do to educate ourselves. I am Friday Jones. I'm the president of the National Assembly of American Slavery Descendants, and Black Civics Collective is doing a pop-up on the Tulsa case. So we're going to do a live reading. I think Dana is in the studio with us today. She's producing. So let's shout out Dana Dorsey. I believe we have some photos of folks that are living. They're not ancestors yet. So these are the folks that we're going to be talking about in the case, in this Tulsa case. This is when everyone was alive. So we have Leslie Benenfield Randall, Viola Fletcher, Muriel Watson, and I believe Hughes Van Ellis Sr. was alive at that time. That's the gentleman that we see. Now it's the estate of Mr. Hughes Van Ellis Sr. And so we want to get right into it, but we have a short video that we want to play before we jump into the reading.
I still see black men being shot, black bodies lying in the street. I still smell smoke and see fire. I still see black businesses being burned. I still hear airplanes flying overhead. I hear the screams. I have lived through the massacre every day. Our country may forget this history, but I cannot.
There's still no hospital in North Tulsa. It was never rebuilt. The land that belonged to black landowners was taken by the city, never given back. The city still has possession of much of that land. So this is about the continued harm. It may have started with the massacre, but there has been ongoing harm to this community for over 100 years that has kept it from rebuilding.
All right. So we're back, and I have just pulled up this particular case so that we can just walk through it. And again, we are reading for the purposes of learning. These are the cases that affect our reparations fight. We know that we are historically told that time limits pass. Sometimes there's quirks in the law that actually are made in a way so that the repair simply cannot be done and had. And all of these things need to be addressed in the actual court of law. And we know just from a very Black civic standard that the court system in the United States, which has ultimately been very much used against us, is the third arm of government. And we also have to participate in it. And so With that, this is 2024. Okay, so this is Oklahoma in Court 40 in the Supreme Court of the state of Oklahoma. And again, the plaintiffs, the appellates are Leslie Benenfield Randall. We all know her as Viola Fletcher, Mother Viola Fletcher, Mother Muriel Watson, and of course the estate of Hughes Van Ellis Sr. versus the city of Tulsa, a municipal corporation, Tulsa Regional Chamber, a domestic nonprofit corporation, the Board of County Commissioners for Tulsa County, Oklahoma, Vic Regalado in his official capacity as the current sheriff of Tulsa County, and Oklahoma Military Department. Those are all of the governmental bodies that actually participated in one capacity or the other during what we know as the Tulsa, Oklahoma bombings. And for so many of the young people who really seem to have apathy around this case, we need to understand that bombs were dropped on African Americans on American soil. And so, again, this is an appeal case from the District Court of Tulsa with the Honorable Caroline Wall, District Judge, presiding. Plaintiffs, survivors of the Tulsa Race Massacre, brought suit against defendants seeking abatement of the public nuisance caused by the defendants' unreasonable, unwarranted, and or unlawful acts and omissions that began with the Tulsa Race Massacre of 1921. We all know this happened in the Greenwood section, which was basically the black part of town, but continuing and continue to this day. Plaintiffs also sought recovery for unjust enrichment for defendants' exploitation of the massacre for their own economic and political gain. The district court granted defendants' motion to dismiss, finding plaintiffs' petition failed to state a justiciable public nuisance claim and failed to allege a legally cognizable abatement remedy, and dismiss plaintiff's unjust enrichment claim for failure to cure a defective pleading. Plaintiffs appealed, asserting the district court erred and dismissing both claims. We retained this matter on plaintiff's motion and hold that plaintiffs' grievances do not fall within the scope of our state's public nuisance statute, and plaintiffs' allegations do not support a claim for the equitable doctrine on unjust enrichment. Matter previously retained for disposition, trial court affirmed. Demario Solomon Simmons, which is the attorney, and Jordan Johnson, Solomon Simmons Law, Tulsa, Oklahoma, Jane L. Not Bass Law, Oklahoma City, Oklahoma, LaShandra Peoples Johnson, and Cordall Cephas Johnson Cephas Law, PLLC, Tulsa, Oklahoma, J. Spencer Bryant. This is naming all of the different attorneys who appeared, and I'm not going to name them. Okay. Unlike most cases that come before this court, the tragedy informs the basis of the present appeal, is acknowledged and memorialized, at least in part, by Oklahoma law. In 1997, the Oklahoma legislature passed House Joint Resolution 1035, which established the 1921 Tulsa Race Riot Commission and tasked the commission with developing the historical record of the racial violence that transpired in Greenwood community on Tulsa, Oklahoma between May 31st and June 1st, 1921. We now know these events as the Tulsa Race Massacre. So that means folks died and were massacred. When the commission completed its final report in 2001, a portion of its findings were inscribed into Oklahoma law. The commission found that there was a breakdown of the rule of law in Tulsa on May 31st, June 1, 1921, after a white mob assembled in the city threatening the life of Dick Rowland, an African-American who was accused of raping a white woman. The commission found strong evidence that some local municipal and county officials failed to take actions calm or contain the situation. People are always telling us to comply with the law, and yet there was no compliance with the law, or contain the situation once violence erupted, and in some cases became participants in the subsequent violence, which took place on May 31st and June 1st, 1921, and even deputized and armed many whites who were part of the mob that killed, looted, and burned down the Greenwood area. This would be in, if any of you follow me on social media, I am Friday Jones. My ancestors did not own slaves, and I often ask, what were they doing? So what were they doing in 1921? The destruction inflicted upon the Greenwood community by the mob was staggering, including the killing of between 100 and 300 people, predominantly African American, and the destruction of more than 12,000 homes, schools, churches, and businesses. Even after the initial violence subsided, local officials engaged in actions that exacerbated the harm. State and local officials participated in the mass arrest and detention of Greenwood residents, and Black detainees could only be released upon the application of a white person. When Greenwood residents attempted to rebuild their community, they were met with frustration. In one notable example, local officials attempted to block the rebuilding of the Greenwood community by amending the Tulsa building code to require the use of fireproof material in rebuilding the area, thereby making costs prohibitively expensive. And so we see the law being used against us to basically price us out. We talk about wealth and the state of our wealth heading to zero by 2053. These are tactics and mechanisms being used today. We saw that in the California California State Legislature with Representative Assemblywoman, I believe Kate Sanchez, I think is her last name. She basically said that the total recommendations, which cost $800 billion, would bankrupt California. And so basically first, second, and third immigrants shouldn't have to bear the cost of that. And so we see laws being used against us. The 800 billion was a dog whistle because the 3 bills or the 5 bills that were going up against the state of California legislature did not or will not tally $800 billion. And so we got to pay attention to these cases. So let me jump back in. Background. On September 1, 2020, plaintiffs in their original petition asserted claims of public nuisance and unjust enrichment. In their public nuisance claim, plaintiffs alleged that as a result of the massacre and the unlawful actions of defendants, both during and after plaintiffs continued to face racially disparate treatment and city-created barriers to basic human needs, including jobs, financial security, education, housing, justice, and health, that annoy, injure, and endanger their comfort, repose health or safety, and render them insecure in life or in the use of their property. In their unjust enrichment claim, plaintiffs allege that defendants appropriated the name Black Wall Street, a moniker for the Greenwood neighborhood, for use in marketing efforts to promote the city of Tulsa as a tourist attraction. So they wanted to profit on our pain. We know a lot about that, without returning any of those benefits to the members of that community, meaning the members that had actually been harmed and displaced. Defendants sought dismissal on several grounds, including inter alia, failure to comply with the Government Tort Claims Act, failure to state a cognizable public nuisance claim, equitable defense, lack of standing, and constitutional issues with the requested abatement remedies. The motions to dismiss prompted plaintiffs to file the First amended petition. Both the petition and the First amended petition sought a broad set of remedies, including declaratory judgments regarding the role of public officials in the massacre and lasting harm it created. 2, injunctive relief preventing defendants from obtaining any further financial benefit from the massacre. 3, an accounting of any financial benefits received already. And 4, a number of financial and social remedies to abate the alleged ongoing public nuisance. Defendants renewed their motion to dismiss plaintiff's First Amendment petition. While the motions to dismiss were under consideration, we issued a decision in State ex rel Attorney General of Oklahoma versus Johnson & Johnson 2021, Oklahoma, holding that the opioid manufacturer's actions in manufacturing, marketing, and selling prescription opioids did not constitute a public nuisance. In response to the Johnson & Johnson decision, plaintiffs submitted a notice of supplemental authority and supplemental memorandum of law addressing the decision's impact on their public nuisance claim. As the public nuisance claim, the district court found that only those plaintiffs who were survivors of the massacre, i.e., Leslie Benningfield Randall, Viola Fletcher, and Hughes Van Ellis Sr., had standing to sue. So this is important to reparations. We're doing lineage-based reparations. Justin Hansford, Howard University director of the Threshold Center, attorney who is also on the People of African Descent forum, the permanent Forum on People of African Descent with the United Nations, has stated that there are 3 classifications in a lineage-based claim. Those 3 classifications include survivors, like we see here in the Tulsa case. It includes their descendants. And so Tulsa is intentionally trying to not enrich and bring redress to the descendants. And then, there are Black folks who are generally harmed by specific laws and or policy. This is very important here. And again, we need to pay attention. The district court dismissed plaintiffs' ongoing public nuisance claim, which sought relief for the unlawful acts of the defendants in the decades following the massacre. Specifically, the district court determined that plaintiffs' claim of an ongoing public nuisance implicated political questions that were not within the purview of the plaintiffs' requested relief, violated the separation of powers doctrine. The district court also dismissed with prejudice the public nuisance claim against then named defendants Tulsa Development Authority and Tulsa Metropolitan Area Planning Commission because neither body existed at the time of the massacre. These are challenges in the law of Oklahoma that, again, we as reparationists, we as the descendants of persons who were enslaved in this country by in the form of chattel slavery, we have to be aware of the games that government is willing to play with our justice claim, because it is a debt and it is falling due. It's past due. The notice has been served. The district court also dismissed the only remaining public nuisance claim without prejudice, that the survivor plaintiffs stemming from the massacre itself, finding the plaintiffs had failed to state a cognizable abatement remedy, but granted plaintiffs leave to amend their petition, meaning they expected these 100-year-old people to not only sue, but they had to come back with cognizable abatement remedy, meaning they had to do the city attorney's job, the state of Oklahoma's job. They had to do the job of the people who we pay with our tax dollars to legislate. This is so just, anyway. In its ruling on defendants' motions to dismiss plaintiffs' unjust enrichment claim, the district court noted that the parties stipulated there were curable defects with the unjust enrichment claim. And pursuant to the parties' joint request, the district court dismissed the unjust enrichment claim without prejudice and with leave to amend. In their second amended petition, plaintiffs revised their proposed abatement remedy as to their public nuisance claim and made the stipulated changes to their unjust enrichment claim. Defendants renewed their motions, dismissed on largely the same grounds after the district court held a hearing on the renewed motions to dismiss. It incorporated its previous findings and dismissed the second amended petition with prejudice. So now they're saying, you can't come back here. We told you to go work harder. People wonder how culturally we as Black Americans, as American freedmen, adopted this, we know this motto very well, this old Negro motto, and it basically goes, you got to work 10 times harder. We got to work 10 times harder because these are the paces and the steps that we have put through in order for us to actually realize our full citizenship. So the district court provided the following reason. The court determines plaintiff's second amended petition fails to state a justiciable public nuisance claim under Oklahoma law. Plaintiff's second amended petition fails to allege a legally cognizable abatement remedy. Plaintiff's second amendment petition fails to secure the defect in pleading which the court found to exist and liberally granted leave to amend pursuant to Oklahoma laws. Plaintiffs filed their petition in error, and accompanying motion to retain with this court, we retain the matter of disposition and held oral arguments in bank. Oh, that's a legal term. I gotta ask one of my attorney friends. If one of my attorney friends are tuning in, tell us what that means in bank. Standard of review. We review court's order granting a motion to dismiss, and under the de novo standard, Danny versus Miller, 2016, Oklahoma, motions to dismiss are intended to test the law that governs a claim rather than underlying facts. Thus, that's an important one. I can't actually gloss over that. Motions to dismiss are intended to test the law that governs a claim rather than the underlying facts, which means they're going to stay to the law, not underlying facts. Thus, when evaluating whether a petition was properly dismissed, we take as true all allegations within the petition, as well as any reasonable inferences that can be drawn thereof. Motions to dismiss are generally disfavored and should only be granted when there is no set of facts that can be drawn from the petition that would warrant relief. So for Black people in America, and Oklahoma is not the only time bombs have been dropped on Black folks. Bombs were dropped in Philadelphia on Black people. Even though they were not bombs, Black folks have literally had their towns flooded with lakes and water just to bury people out. We've also been burned out. So this is deep. This is America, you all. A pleading must not be dismissed for failure to state a legally cognizable claim unless the allegations indicate beyond any doubt that the litigant can prove no set of facts which would entitle him to relief. Frazier versus Bryan Memorial Hospital in 1989, Oklahoma 73rd Court. We adhere to the standard that the purpose of a motion to dismiss is to test the law that governs the claim, not facts, in McGee versus L. Patio. Thus, we must take as true all of the allegations in the challenge pleading together with all reasonable inferences that can be drawn from them. We only find dismissal appropriate if there are no cognizable legal theory to support the claim, or there are insufficient facts under cognizable legal theory. On appeal, plaintiffs' propositions of error can be summarized as two primary contentions. The district court erred in dismissing their public nuisance claim for failing to state legally cognizable abatement remedy, and two, the district court erred in dismissing their unjust enrichment claim despite a purported stipulation that the defects in the claim were curable. Plaintiffs' grievances do not fall within the scope of our public nuisance statute. So now they're telling why the way they chose to proceed, and we need to learn from this as well, how we proceed in legal findings. We read the Fearless case. How they chose to proceed was it mattered in the end, and it's mattering with this Tulsa case as well. And they had to find a legal standing in order to even seek remedy based on actual losses. So I'm going to continue. Plaintiff's primary contention on appeal regarding the public nuisance claim is that the district court functionally imposed a heightened pleading standard by requiring plaintiffs to identify a legally cognizable abatement remedy. I agree with that. Specifically, plaintiffs note that Oklahoma is a notice pleading jurisdiction, and under a notice pleading regime, they are not required to identify a theory of recovery. Defendants counter that plaintiffs must show there is some justiciable remedy in order to adequately state a claim for public nuisance. Defendants also argue that even if plaintiffs have adequately stated a claim, this court can and should dismiss the public nuisance claim on those grounds. Oklahoma's law states that a nuisance exists when the offending party unlawfully does an act or omits to perform a duty, which act or omission either first annoys, injures, or endangers the comfort, repose, health, or safety of others, or second, offends decency, or third, unlawfully interferes with, obstructs, or tends to obstruct, or renders dangerous the passage any lake or navigatable river, stream, canal, or basin, or any public park, square, street, highway, or fourth, in any way renders other persons insecure in life or in the use of their property, provided this section not only applies to pre-existing agricultural activities. A nuisance is public when it affects at the same time an entire community or neighborhood or any considerable number of persons, although the extent of the annoyance or damage inflicted upon an individual may be unequal. I just want to say here, Black people have a way of like ringing the bell on America. We say if this is happening and can happen to us, it means it can happen to any of us. It means it can happen to white people. It means it can happen to Asian people. It means that it can happen to our indigenous family. It can happen on American soil to anybody who is an American. And you need to be vested in these people in particular and in the descendants of people who were persons who were enslaved in the United States and having redress, because if the Black community, if African Americans that descend from persons enslaved are not made whole, then any and all of the things that have been done to us as a people can and will at some point be done to you by your own bodies of government, whether they are state or the federal government itself. All right. I'm hopping back in here. In Johnson & Johnson, we explained in applying Oklahoma's public nuisance statute that over the past 100 years, we have limited public nuisance liability to defendants. One, committing crimes constituting a nuisance or causing physical injury to property or participating in an offensive activity that rendered the property uninhabitable. And this was the state Attorney General of Oklahoma versus Johnson & Johnson. For instance, in the Crushed Stone Company versus Moore in 1962, we recognized that the operation of a lime rock quarry constituted a public nuisance due to the conclusive explosions, projectile debris, and dust that filled the air and settled on nearby properties. Likewise, in state X-Rail Field versus Hess, Oklahoma, we found that exhibition, distribution, and sale of obscene materials as an adult bookstore in violation of Oklahoma law constituted a public nuisance. But somehow, bombs being dropped, and if my history is correct, it was, what is the name of that oil company? I'm going to find it when we take a commercial break. That actually, they are the ones that had the plane. So before you pull into their oil station, you should know that you're paying someone who contributed to our family members here who are not having justice in these here United States. Anyway, I'm going to keep on reading. In Johnson & Johnson, the present matter is distinguishable from traditional nuisance cases like Crushed Stone and Hess. In Johnson & Johnson, we were asked to address whether the conduct of an opioid manufacturer marketing and selling prescription opioids constituted a public nuisance. In Johnson versus Johnson, we acknowledge that the opioid manufacturer's conduct annoyed, injured, and endangered the comfort, repose, health, and safety of the public by contributing to the opioid epidemic. Nevertheless, we declined to expand public nuisance liability to cover the opioid manufacturer's conduct because it was not criminal and did not invoke property-based conflict. Wow. So they're basically saying that because they didn't expand public nuisance liability to this manufacturer, essentially they don't have to do that for themselves. So your government doesn't have to be responsible to you. Applying the nuisance statutes to lawful products as the state requests would create unlimited and principal liability for product manufacturers. That is why our court has never applied public nuisance law to the manufacturing, marketing, and selling of lawful products. Today, the court is asked to expand its public nuisance liability once more to include the lingering negative economic and social consequences stemming from unjust, violent, and tragic moments in our history. So we are being, as a people, reduced to just unjust, violent, and tragic moments in our history. The fact that these people are alive does not seem to invoke any laws, invoke any protections. It doesn't protect us under the 14th Amendment. This is something that all Americans need to be paying attention to. The legislative authority remedies for a public nuisance are indictment or information, a civil action, and abatement. Applying these remedies to the plaintiff's claims, any individuals who could be indicted or held criminally liable for the massacre have long since passed away. So we're not bringing redress, even though these people may have been employed by our government. The fact that they died and the government is still standing, we're not liable for those employees' actions. Plaintiffs do not point to any physical injury or property in Greenwood rendering it uninhabitable that could be resolved by way of injunction or other civil remedies. So the fact that we bombed you all into oblivion and you can't point anymore to that property or show your loss in a modern context, so we also can't make you whole. And as the district court noted, plaintiffs' proposed abatement remedy does not constitute abatement, but rather a series of affirmative policies directed at offsetting or minimizing the aforementioned inequities. So in the beginning, we played that video with Mother Fletcher, and she's talking about how she doesn't have physical harm, but she has like these nightmares. She can remember. So unless she didn't lose a limb, or a foot or a toe or the nose on her face. And so because she has no physical scars, her mental and trauma have no standing before this court and before the state. The inability of legislative authorized public nuisance remedies to redress the harms following the massacre highlights the plaintiff's grievances do not fall within the scope of our state's public nuisance statute. Plaintiffs seek abatement to remedy the blight to property caused by the defendant appellees that began with massacre and persist to this day. Plaintiffs do not plead any current physical injury to property or allege that any property is currently uninhabitable. Wow. Rather, plaintiff's public nuisance claim is predicated upon the blight to property caused by defendant appellees that began with the massacre and persist today. Okay, for my mental health, we're going to go to a quick commercial break. I'm going to find the name of that oil company that was part of this, so that, and they have a station right on the four corners of La Brea and Slauson in Los Angeles. We gonna put them into this. They're not in this particular hearing, but you need to know this history. Let us take a quick commercial break so I can get myself together and get my fury in check. And Black Civics Collective will be right back.
Welcome. We are the National Assembly of American Slavery Descendants. Our mission is to advance the national movement for reparations. The United States Office of Management and Budget set 5 minimum standards for collecting racial data. The Black race is defined as a person having origin in any of the Black racial categories of Africa. NAASD has recommended that the OMB disaggregate data to accomplish 3 goals: decouple race from ethnicity, create an ethnic term that exclusively identifies descendants of persons enslaved in the United States, and create an ethnic term that preserves the American freedmen's political status. The ethnogenesis of the African American identity is a result of ethnocide. The identity is from a people with shared history. race identity plus ethnic identity equals peoplehood. Together, we can fix this dilemma with the OMB. We can build a coalition, grow the movement, and create a unified demand. What can you do to get involved? You can join NAASD today at www.naasd.org. You can email the OMB using our toolkit, or you can donate to NAASD so that we can continue this work. Thank you for your time, and stay connected with us on social media at NAASDORG. We are on Twitter, YouTube, Instagram, TikTok, Facebook, and LinkedIn. You can also sign up for our newsletter at www.naasd.org.
All right, party people, we are we are back, and I'm just everybody take a breath, take a breath, take a breath. I am Friday Jones. You are tuned in to the live reading of the recent Tulsa, Oklahoma decision. Part of what we do here at the National Assembly of American Slavery Descendants is to make sure that we educate as part of our programming, and Black Civics allows us to do that. For folks tuning in, I see we have 26 people here. Thank you for tuning in live, but please make sure you share the reading that's happening now, because this is important. It's important to our work. I'm going to continue. I believe I'm at the top of page 11 of this particular opinion. So let's keep going. Okay, accepting as true that the massacre is a continuing blight within all property in the Greenwood community, and that the pall of the massacre continues to envelop the Greenwood community over 100 years later, plaintiff's claim does not present a conflict resolvable by way of abatement. And even accepting as true plaintiff's claim that the lingering economic and social consequences of the massacre still to some extent endanger the comfort and repose of the Greenwood and North Tulsa communities, those lingering consequences over 100 years later, standing alone, do not constitute a public nuisance, as the term has been constructed by this court. So they just make it up. They just bend the terms. Lord, if this is not the devil's work, I don't know what it is. Oh my goodness. The continuing blight alleged within the Greenwood community born out of the massacre implicates generational societal inequities that can only be resolved by policymakers, not the courts. The clip that you saw in the beginning were these Tulsa survivors before Congress. That clip comes from them before Congress. Those are the policymakers. They didn't get redress from the federal government, so they came back to Oklahoma where it happened. And allegedly, I'm going to say that to provide coverage, allegedly, it was Sinclair Oil's airplane that was used to actually drop the bombs on these people, on this African-American, very affluent Black Wall Street community in Tulsa, Oklahoma. Let's continue. Today's holding is consistent with our recent public nuisance jurisprudence, expanding public nuisance liability to include lingering social inequities from historical tragedies. We are just chalked up to historical tragedies. The fact that human beings are in front of your face does not matter. An injustice runs the risk of creating a new, unlimited, and unprincipled form of liability, where both state and non-state actors could be held liable for their predecessors' wrongdoing. Translation: we are not changing status quo. We will not change to repair you people that we know were harmed. That is what we are up against in this fight. And you need to know your enemy when you are effectively at war, people. And this is a war. This is not light engagement. It is not for the weak. It's not for the meek. If you are going to be part of this current reparations movement, and I do invite you all to sign up for our newsletter at www.nwasd.org to be part of this movement that is growing and is brewing. If you are mad about this, you need to be part of an organization that is going to move people in step. This is a horrible decision. It sets horrible precedent. It dismisses people that endured the harm. And so when we talk about this harm-based model, and we got to go through all of this scrutiny and the things that are required, I've talked about this before, we have to be paying attention to what these courts are doing and saying. As we said in Johnson and Johnson, to hold otherwise would place Oklahoma courts in an unorthodox position of fashioning remedies for these claims or venturing into realm of outright policy making, both of which we decline to do. As we said in Johnson and Johnson, the court defers the policy making and legislative and to the legislative and executive branches. Again, they're reminding you that the court is the third branch of government. And you know what Brown versus Brown did? Do you know what that case did? It forced the Supreme Court to actually change legislative policy. And so it can be done. It can be done. Today, we hold that the relief is not possible under any set of facts that could be established consistent with the plaintiff's allegations. When a trial court is considering ruling, it should not ask whether the petition points to an appropriate statute or legal theory, but whether relief is possible under any set of facts that could be established consistent with the allegations. Plaintiff's grievance with the social and economic inequities created by the Tulsa race massacre is legitimate and worthy of merit. However, the law does not permit us to extend the scope of our public nuisance doctrine beyond what the legislature has authorized to afford plaintiffs the justice they are seeking, according to affirm the district court's dismissal of the public nuisance claim. We've got about 15 minutes, family. Thank everyone who's watching. Please make sure to like and subscribe to our YouTube channel. We are trying to grow that. Also, please make sure you sign up for our newsletter. This is gonna be the last section that I read. This particular document is 24 pages, but I'm gonna go through this this last section because we've covered most of it. We've covered what the plaintiffs' grievances were. We've covered why this opinion was rendered. I always encourage people, because the attorneys are stated on these documents, start building your own legal, what's the lack of contact sheet, in case you need some legal representation, in case you need legal representation in this space, so that you're working with people who have already done this kind of work. You should be building your contact list of attorneys as we do these pop-ups and these reads, because attorneys' information is usually on the very first page of these court documents. So let me get back to this. The record reflects no evidence of a stipulation on defendant's behalf to forego further motions to dismiss. With respect to their unjust enrichment claims, plaintiff alleges that defendants stipulated in the district court that they would forego any further motions to dismiss the claim if plaintiffs made certain amendments to the second amended petition. Defendants argue that plaintiffs mischaracterized the stipulation, specifically that there was never an agreement to forego further motions to dismiss. On review, we found no evidence of a stipulation on defendant's behalf to forego further motions to dismiss the unjust enrichment claim. During the hearing on defendant's motion to dismiss, City of Tulsa noted the plaintiff's unjust enrichment claim sought damages for injuries that occurred beyond the 2-year statute of limitations. They always use the 2-year statute of limitations. New York and California recently brought back the ability for survivors, even New Jersey, survivors of sexual assault, to have more time. Oklahoma, as a state, could very easily go back and extend so that there could be redress, legal redress. When the issue was raised again at subsequent hearings, the parties announced a plan to strike certain portions of the proposed remedy on the unjust enrichment claim that addressed injuries preceding the 2-year statute of limitations. Specifically, counsel for plaintiffs stated, okay, so the parties have agreed with respect to page 69, paragraph 10 of the petition, that plaintiffs will file a Second Amendment petition that strikes the subparagraph A through N of that paragraph, and that will be the only purpose for the amendment. And then defendants will rest their existing motions to dismiss without respect to their legal arguments. And there won't be a new round of briefings related to the Second Amendment petition. Thus, the stipulation on which the plaintiffs rely does not support their contention. The defendants agreed to forego any further motions to dismiss the unjust enrichment plan. Rather, the record reflects the defendants intended to pursue a dismissal of the unjust enrichment claim, even if the stipulated defects were cured. Even so, plaintiffs allege that the district court was wrong to dismiss their unjust enrichment claim because it was sufficiently pled. Defendants counter with a number of purported legal deficiencies in plaintiffs' unjust enrichment claim, including lack of standing and availability of adequate remedies of law. Based on the record before us, it is evident that the stipulation referenced by plaintiffs did not entail an agreement with defendants to forego further motions to dismiss. The record reflects that the defendants maintained their intention to pursue dismissal of the unjust enrichment claim, notwithstanding any stipulated amendments. Accordingly, we find no evidence of a stipulation on defendants' behalf to forego further motions to dismiss the unjust enrichment claim. This is a slight win. And again, I'm going to stop here because we are at 10 minutes out. You know, I have a few more cases that Black Civics Collective is going to do a pop-up on. Understanding court proceedings, understanding the law is part of being civically engaged. For the folks who are watching us live, please share this. I'm going to drop, oh gosh, I can't drop where I got this file from. I got to figure out a way to get this file to folks in circulation if you want to read it. We will figure that, our comms team, our communications team will figure that out. It's Saturday afternoon in Los Angeles. You know, it's late Saturday afternoon on the East Coast. This requires a movement, people. This requires us working from coast to coast. This requires us to understand when it's time to rally together and how we rally together. We definitely are grassroots organizers, but we are also thought leaders. And we have the ability to free thinkly in this space that we call reparations. And it's important that we put our elders in their proper place. One of the fastest growing populations of homelessness in Los Angeles is basically retired people. They can't afford to keep up. If we don't get this reparations right, our mothers and grandmothers and grandfathers and our fathers and the uncle that never had any kids, the auntie that never had any children, have the potential to be on the street. Mental health issues are developed after essentially being neglected, unheard, and it's coping. You cope. Your mind and your psyche, the psychology of it, you can Google it. You break down. We have some of the largest negative health outcomes out of anybody else in the United States. And we have 18-year-olds who post videos basically saying in California, which is leading the reparations battle, that African Americans are not entitled to it, and yet we pay our taxes here. We are in a place that is starting to just disgust me. And it's starting in a positive way to affect how we move forward. But it's very important that we have our own media. And the Black Civics Collective brings you, we have our regularly scheduled shows, that are informative and help you advocate and self-advocate. These cases also help you to self-advocate. This is our educational part of what we do as a nonprofit. So tell family members to join this organization. Can we, Dana, bring up our survey? We have a survey that we're taking because we want to be part of the legislators. We want to teach you how to legislate. When legislation actually wins, we actually want to share it out with our membership so that people understand you don't have to always reinvent the wheel. We should have archives, and we will. When we're working on a new website, we're going to start archiving these cases because we want people to read them and to understand them. I thank you guys so much for being with us. Use your QR code to take our survey, share our survey with your friends and family. Once we close this out, please retweet, share on Instagram this video so that people can understand how law is being used against us. Thank you so much for your time. And we got one more little screen that we need to share. This one brings me joy. I learned a lot of things from my grandfather. He did things like take us fishing, and he taught us kids how to shoot a revolver. All of the grandkids, girls and boys, it didn't matter to him. He thought we should know how to shoot. So he used to let us shoot cans on top of these wood sticks. I don't think our parents knew he had us doing that. But for all the fathers, for the grandfathers, for the uncles that step in like fathers, for our adoptive fathers, happy Father's Day to you. Happy Father's Day. Enjoy your day tomorrow. Enjoy your family tomorrow. I am Friday Jones on social media. Please follow the National Assembly of American Slavery Descendants on all of our social media. We are at NAASD.org. We have swag on our website, so visit our shop. Make a donation. The work we do, it does cost us a little bit to keep the lights on, so make a donation. A free and easy thing that you can do is subscribe to our YouTube channel so we can grow it out. Like the videos that you see there, and share them. Thank you so much for giving a little bit of your time. Happy Juneteenth. Happy Father's Day. I'll see you guys on the outside. Take care.